Looks like we're live, people. How is everybody doing? Okay, Robert is potentially a few minutes late, but it's going to be just as well because I'm going to do the intro, see who's in the house, and talk about what we're going to talk about and what Barnes and I are doing in general now. And it's actually going to be very interesting. First things first, if everybody can see me, let's see if we can get a confirmation in the comment section that I am live. This thing on. Let's see. We see Matt Meatbag. Hold on, where did it just go? Meatbag says, I left a comment that Viva should do a podcast with Robert about the Brooks case. Thus, I'm taking full responsibility for this podcast happening. Okay, it looks like we're live in any event. Now, I'm going to try talking slower only during the streams and for one specific purpose. Eric Hunley. I don't know if you know who Eric Hunley is. I did a podcast with him because he's got a podcast called Unstructured. He has managed to convert all of the live streams that I've done into audio format. So I'm going to be releasing them as podcasts, maybe one every other day or one every few days, maybe one a week, just to really milk it for so we don't have to start creating new podcast content. And what I'm going to be doing with Barnes, I should call him Robert or Mr. Barnes, Esquire. We are going to be doing this. If it's not weekly, it's going to be regularly. We're going to do it on this channel. We're actually not going to create a dedicated channel because there's no need to start from scratch somewhere else. People know where to find it. We're going to split everything on the live streams 50-50, just so nobody thinks I am not only taking advantage of Robert for his time, but also for what it brings to the channel. But that's a detail, just so everybody knows that that's what's going on. And then we're going to convert these into podcasts. So whoever doesn't want to listen to a 2-hour live stream can download the podcast. And I'm going to rebrand, hopefully, my existing podcast, just so I can rebrand it to the whatever we're going to call it. And we are looking for a name. We've been floating some names between each other, but we haven't come to a determination yet. And what we think, maybe we're going to shortlist 3 names each and then go to social media to see who likes what the most, and then maybe go with the most popular name. If anybody has, we like jokes, but if anybody has serious names for what the podcast would be, at first I was reluctant to have it be Barnes and Fry because you have Barnes and Noble, but then I was thinking like you might actually get some good accidental runoff from people who are looking up Barnes and Noble and then come across Barnes and Viva, whatever it is. Barnes and Noble still open? Anyhow, so that's the plan in the long run. We're going to be doing this. I'm going to try to talk slower for the audio for the podcasts. I'm going to read the super chats slower and more deliberate. I'm going to read the comments slower and more deliberate. I still reserve the right to miss super chats because it is unfortunately too much sometimes, and I don't want it to interfere too often with the discussion because it's only me right now. Incidentally, everybody, tweet this out, share it on social media because I keep getting told the notifications are slow. YouTube. Oh my goodness. I may have to do a video tomorrow about the new feature on YouTube. And Nate, who I just saw in the house, Nate Brody's in the house, and I don't know if Uncivil Law is in the house. YouTube has this thing where you rate your own video as to whether or not it's advertiser friendly before publishing it. And then if YouTube determines that it wasn't advertiser friendly, it gives you literally social credit or a social credit score on YouTube. I had literally, of all the videos that I put up, they had 6 that were confirmed or that were deemed to be advertiser unsuitable or unsuitable for advertiser, whatever, demonetized. 3 of which were confirmed on manual appeal, and 3 of which I didn't even bother asking for because they were live streams and wasn't even worth it. Of all the videos, they've got 6, and they said my score was low on YouTube. And as if that wasn't enough, I'm going to go back now and just check how many times my request for manual review has been overturned, because if we're going to start measuring each other's scores, we're going to do it. That was a total side note, parentheses. Let me see what we got here. We got Alex T. Keep fighting the good fight and presenting facts. I do my best. You know, the funny thing is, my CNN is fake news. Was it Jim? No, it wasn't Jim Acosta. Brian Stelter. Everyone loved that. Crazy until YouTube killed it. You know, the momentum with demonetizing it. Nobody really likes hearing that CNN has a good legal argument. Jenna Ellis Esquire has not yet gotten back to me on my video where, unfortunately, a good argument in law is a good argument in law regardless of who presents it. I mean, that's a reality in life also. A good argument is a good argument regardless of who presents it. And it's something we've sort of forgotten in this world in which we live, where we discredit ideas based on discrediting the interlocutor. And it's a bad way of thinking. It's a bad way of presenting arguments on both sides. The individual behind the argument is irrelevant to the validity of the argument. Barnes and that Fry guy. I'm going to go ahead and screenshot that. Well, let's see. By the way, thank you very much, Alex. Andrew Quintal. Yes, I've seen you before for sure. Pretty fly for a Fry guy, but that only works for one individual. Paul Kuko, thank you. What do we got here? Darren Duhoda says, would someday love to hear your and Barnes' thoughts on jury nullification. I would have to look into it before I could even have an opinion. We don't, like I've said in previous vlogs, we don't do jury trials for civil matters in Quebec, in Canada. So I've never dealt with a civil jury. The heck am I talking about? With a jury in my life. I once went for jury duty. Only I knew I was going to get disqualified because I'm an attorney and we can't sit on jury, but I wanted to see how the process went. And it was pretty fascinating for the time that I got to see. Viva Fries Vegas. Viva Las Fragas. So that's the plan in the long run. Sorry, it's 6 minutes in and I'm waiting for Robert to get here, but let's see that. Tourney Net says Barnes fries the law. Not bad. That's creative. I want to try to avoid using fries in the aggressive, destructive sense for a number of reasons. Yeah, wrong think, Yotoku. You know, it's an interesting thing that they started with this this rating your own videos for the purposes of facilitating monetization. But I told, I think it was Nate I was having the discussion with, I said, this is going to turn into, on the one hand, it's my prediction, self-censorship, because I'm going to rate myself harder because I don't want YouTube thinking that I'm trying to pass offensive content off as monetizable. And then it's going to turn into sanctionable conduct where, if you didn't rate your video properly, you know, it'll become part of the terms of service. I'm imagining, which will be a stink that will have to be made. Jay Leon said the law by Fry Derek Barnes Tiat. The law. Well, I could Frederick Barnes Tiat. Well, or just the law by Barnes and Fry. Barnes, Fry, and the law. Not bad at all. Thank you very much, by the way, for the super chat, Jay Leons. So today we're talking about, we're going to have three subjects. I wrote them down just so I don't lose them. DACA SCOTUS ruling, the Rayshard Brooks incident, and Chaz Chop. Because apparently now it's called Chop and not Chaz, and I wanted to make sure. I got a kid coming downstairs. Keith Wagner, Viva La Barnesy, and we got Barnes and the Vlog Dog. That's not bad. Yeah, you can come down. Come down. We haven't started yet. People, is he? Yes, he is. He is wearing proper attire. So we got one kid who wants to come down and say hi before we start the stream, and a dog who looks like he might. You coming here? Okay. Oh, say hi to the world.
Hi.
Okay. Now you're going to leave us alone for 2 hours. Okay, 1 hour. You have no measurement of time, so get out here. Go. Go, get me something upstairs. Go get the... Okay. So that's where we're going with this. Oh, the third was Chaz Chop. So it's interesting. I was not totally familiar with the DACA ruling. I was not about to read the decision because I can summarize it, but I think I might just summarize it badly. But I think I've got questions for Barnes because I sort of understand the concept and I understand what I have questions about with that. With Rayshard, if anybody has not yet seen Nate Brody's video on the subject, Nate Brody is one of the dozen or so lawyers on YouTube now. You got Nate Brody, just to name them all if I can. Uncivil Law, Leonard French, Steve Lito, me, Legal. Who are the other ones? Anyway, some people can name the other ones. But Nate Brody put out a video on the Rayshard incident, which is extremely informative. I mean, if all that you're getting is from the news, it's going to be, it'll probably change your perspective. It's just extremely well researched and well presented. So check out Nate Brody's video on the subject. One thing you're going to be noticing, I'm going to be sweating like an absolute beast during this thing. Oh, wait a minute. Brian P says I skipped his question. We got the law with Barnes and a side of Fry. Not bad, Nate. Not bad at all. Hold on. I seem to have missed someone's question. We got Barnes on the Vlog Dog. Am I getting trolled again? I think I might be. Okay, if I missed your question, Brian P., don't post a super chat. Just ask it again, and I'm going to get it. Okay, I'm going to be sweating like a pig, so I apologize if you can see it. I have my glistening rag on the side, just in case. AC in the house is not. We have that stupid wall mount. Even when it works, it doesn't work all that well, and it doesn't work all that well. Raz Simone for president. I don't know who that is. Jared, thank you. Okay, now I'm looking for Alex P's question if I missed it. Because I don't... Brian P. Sorry, Brian P. Let me see here if I get it. While we're waiting for Barnes. Okay, well, you know what? Let's just get some questions now. We got Dapper Dave says, scary thought, jury intimidation by the mainstream media. Any jury member in big trials that goes against their agenda will be put on blast on their show. It's an interesting thing. That's it's a double... I don't want to say it's a double-edged sword. It's actually just dangerous on both sides. If they're known, that can happen. Then the flip side is keep the jury members anonymous, like we saw in Roger Stone, and then you have your entire other problem, which is potential corruption and not being able to publicly vet the members of the jury in any sort of transparent sense. What's the deal with the firing of the federal prosecutor from New York City? So Robert wanted to talk about that. I told Robert in DM, there's only so many things we can deal with. There's only so many things I can keep up with. Yeah. So anyways, that we may talk about it, but that's going to be just a pure explorative discussion for me because I know nothing about it. The procedure, I think I could have a meaningful discussion, meaningful Q&A about it. Pigs don't sweat. They don't have glands for it. Well then, on that note, so I'm sweating like a dog, but dogs only sweat through their paws and their mouth. I'm sweating like a human who's in an extremely hot and humid house. Barnes, Viva. He said, Viva, Barnes need link for invite. I'm such a moron. God. Sorry, guys. That's very bad. Okay, so give me 2 seconds while I do this. The one time I don't do it, I have it in my... copy link. Sorry about that, guys. That is... certifiably, I'm an idiot. Here we go. Done. Sent. My bad. Okay. Well, that would explain a few things. Let me just go ahead and close my email. Sorry about that, guys. Okay. Thank you very much, Obelix. Yeah. Okay. There he's in. I'll get one last question. Do you think another spike in COVID, like we are seeing in Florida, Arizona, California, etc., will cause a second wave of state-mandated closures? It's an interesting thing. I'm not sure that the U.S. would put up with it. Another set of closures. The flip side is another spike might. The spike has to be correlated to hospitalizations and fatalities. And if there's an increase in cases, from what I'm reading, and trying to make sense of what's believable and what's not, it might not be the end of the world, because if there's an increase in cases but not an increase in fatalities, you might just be getting more people exposed to it. But I'm not sure how many people in the States would deal with another indefinite lockdown. Would you fight Legal Eagle in a charity boxing match? Jared calling. I wouldn't, not because I'm scared of Legal Eagle or anybody. I'm just scared of being that one guy who gets punched in the face and doesn't know that I have a weak vein in my head and dies of an aneurysm from a punch that would otherwise be totally innocuous for any normal person. I've been told I have something called thanatophobia, which is the fear of death. Okay, bring in Barnes in. Sorry about the delay and sorry about the mistake there. Robert?
Hey. I think I'm here.
Okay,
here.
You're here. There's a bit of a delay, so hopefully it catches up.
Sure, no problem.
Okay, yes, it's getting better now. How are you doing?
Good. Just walked in. Got in from the airport. There was more traffic than expected out of Atlanta, so that was interesting, but made it. Okay,
and now are we allowed asking where you're coming from and what was going on?
Sure, yeah. So I was in Richmond, Virginia, basically about I had a case involving a lot of third parties and independent candidates trying to get on the ballot. And so we had a hearing Friday morning in front of the judge. The judge had originally expressed some skepticism because the issue is that because of both the pandemic and the shelter-in-place orders by Governor Northam in Virginia has made it very difficult for third-party and independent candidates to obtain ballot access in Virginia, because the only means they allow for ballot access is petitions that are circulated, that are witnessed, where registered voters sign those petitions in a particular manner. A certain number of petitions has to be in a certain regional diversification, certain number of congressional districts if you're running statewide, things of that nature. And so a whole bunch of parties got together and joined in the suit. Originally, the judge expressed concern that a lot of these cases you get in the states where they say, if you file suit early, if you think, hey, you know what, I think I'm going to have a problem getting on the ballot because of some law or restriction, they say, hey, you filed suit too soon because you don't know if you'll get on the ballot or not. You may get enough signatures, so it's not an issue. If you file suit late, in other words, you file suit only after you realize, okay, I'm not going to be able to get on the ballot under this time frame, then they have a tendency to say, oh, you filed suit too late because now we're on the eve of printing the ballot. So there's a constant dilemma where you have to find this magic sweet spot to sue somehow to where you're not either too early or too late. If you're too early, they say, oh, it's not ripe. You haven't yet suffered injury, thus you don't have standing. If you file suit too late, they say latches preclude you under equitable provisions from getting any injunctive relief. In my view, it's mostly a scam because all of these laws are designed by the two major parties to keep out competition. Throughout almost for a century in America, we had no ballot restrictions at all. In fact, the way you used to go to nominate people and vote for people is you just showed up and just said verbally who you were going to vote for. That was from all throughout the colonial era and throughout the constitutional era up until the late 1800s. And then what started happening is, because you had large immigrant populations in the United States, African American, you had a lot of people who were not necessarily literate who were voting. You also had freed slaves who were allowed to vote. And so as a way of organizing the ballot, people started doing written ballots instead to make sure their ballot was properly and accurately counted for. Political machines started to organize, and you would bring your own ballot to the election. So this is slightly portrayed in the movie about the Free State of Jones, which is about the rebellion that took place during the Civil War in the 1860s. A good movie that's historically about 90% accurate, shows an alternative aspect of Southern history that a lot of people don't know about. Relevant, I think, to these days and times when we're talking about so many racialized issues, and there's this perception that there's only been one racial narrative ever in the history of the country. It's really not true. There's been alternative narratives where people have built biracial political coalitions, including represented in that movie. But they go and bring their ballot to the ballot box, or they request a quote unquote Republican ballot to put into the ballot box. So that's what happened. And then what happened is the political elites, in my view, the government came along and said, you know what, to make sure that these ballots aren't fraudulently representing your ballot, or you're not being intimidated to do that, we, the state, we, the government, will now monopolize the ballot. They did so at a time when a good number of people in the northern cities did not speak English, where you had a fair number of people who were not literate. It was deliberately designed to disfranchise working class political machines. But the excuse from the government was, this is for your benefit, to protect you. We'll have a secret ballot. And so we didn't have a secret ballot called the Australian ballot until the late 1800s. But even then, in order to get access to the ballot, all you had to do was show up and give your name. And that was the case in most states for 20, 30 years. And then we had the Red Scare of the 1917 to 1920 time period, where a whole bunch of court cases threw all the law and logic out. Eugene V. Debs went to prison for simply making a speech. I mean, that's how insane we were during the Palmer raids era of the 1916 to 1920. And during that time period, all of a sudden, governments decided, we need a lot of restrictions on the ballot. And every time third parties have been successful in the history of the country, they have suddenly decided, governments and politicians have suddenly decided they need to make sure that the ballot won't be too confusing. This is the official constitutional excuse for all ballot access restrictions, is that if they didn't have them, so many people would be so desperate to run for office that the poor voter would be so hopelessly confused by all those choices that they'd be like, golly gee, I don't know who to vote for anymore if I have more than two choices. This is the whole bogus, it's all a big fat fraud. Justice Scalia admitted it in conference notes that were released by Justice Blackmun after he left the court, where he said the whole thing of cluttered ballots is a phony argument. So I've been trying to fight to strike down these laws for 20 years. Took a lot of cases and have dealt with every shenanigan that the government pulls and every technique that a judge who doesn't want to give me relief pulls. Fought the one Nader case in Arizona for about almost 10 years. It was just insane how many things we had to go through. But so I was in Virginia for the Independent Green Party, the Libertarian Party, Constitution Party, independent candidates, all of whom basically can't get access to the ballot, who have a history of getting on the ballot in Virginia because of the lockdown, shelter-in-place order combined with the pandemic. And we got a consent decree from the government. The government conceded, so they agreed to dramatically lower the signatures by 2/3.
How many signatures do they require?
So typically, like right now, they're only going to have to get about 35% of the signatures that they normally have to get. And so it varies by office, how many signatures you get. So in some cases, you only need like a 50, and others you'll need about 3,500. But that goes way down from where it was, which was between 500 and 10,000. And so we changed the deadline. The deadline had actually already passed for a bunch of congressional candidates. We got that extended by a month. So it gives everybody a chance to get on the ballot, gives everybody a chance to go through. We might end up, the government hasn't yet signed off on all of it. If they don't, then we will have a trial in July in the case. And I think the judge will be more sympathetic to our position. It was fascinating the things the judge disputed. He controverted things that I thought everybody could take for granted or accept as a fact for the purposes of the hearing. Like, for example, is it the public health official's advice that it's dangerous to do the kind of things that petition circulating requires, such as being within a foot of someone, exchanging hands, having them all take notes of things, so on and so forth? That at least a lot of the people thought that was dangerous to do, and that's why they didn't do it. And he was like, well, I want to see evidence of that. And it's like, okay, well, that's a different kind of thing. So we went through it. What I thought would be a half-hour hearing turned into a 3-hour hearing. But ultimately, the government was smart. Particularly in Virginia, they time the deadline to file to the primaries. There's no logical basis for that, because the deadline to file your petition should be tied to when you have to print the ballot. That's not going to happen until mid-September. I was able to persuade the judge that was a big difference between a prior case he'd had and this case, where he thought he could get rid of this case. And it's because in Virginia, it's deliberative. So what happens is the two parties run. And what they're worried about is after the primaries, they're worried about fallout from the primaries, leading people to want somebody else as a third option on the ballot, like Trump Biden is going to create. That choice, there's going to be people who don't like either of those two choices disproportionately. And so consequently, that happens with primaries all the time. Well, they time it so that if you're an independent candidate in Virginia, you cannot even announce your candidacy until a day before the primary. You have to submit your petition a day before the primary. So they deliberately make it very difficult for independents and third parties. And this will be the first time in Virginia's recent history that people will be able to submit petitions is going to be 2 weeks after the primary took place. So it was good wins on both of those accords. There were some people who wanted more, want to challenge the whole system. As a practical matter, that's a hard thing to achieve. And the right case, right place, we will in fact bring that. I will be the lawyer to bring that case. But it needs to be the right facts in the right case. Otherwise, you end up with something like what the church has got with Justice Roberts, or what the DACA outcome was, or what any of the other outcomes have been recently. That bad facts make bad law. And if the people don't like what happened with Justice Gorsuch, that was based on his just plain reading of the law. I actually agree with Justice Gorsuch's opinion. I don't think there was anything political there. He said, can you define homosexual or transgender without reference to gender? He says, if you can't, then firing someone because they're homosexual or transgender takes into consideration gender. And the law is written very broadly and says if there's any consideration at all for gender, it's illegal. So all he was doing was just reading the law the way it was spelled out.
The only point I know on that it was that apparently when they adopted the law, it specifically excluded transgenderism, was one of the things I had been reading. And so they said they didn't want to fight that battle at the time, because then they wouldn't have even been able to get the law passed. And so putting it in now would be improper.
What they're referring to is there's been attempts to amend the law to include transgender, but it wasn't discussed at the time they passed the statute. Now, it's probably a fair conclusion that when they passed the statute, they did not have in mind any firing beyond the issues of biological gender. Because the core conservative criticism is the law is meant to protect biological status, not behavioral that may be a reference biological status. The problem with that is we've long since walked away from that, because when we included sexual harassment, that's behavior. That's not biology. It's behavior that has as a factor biology that takes into reference biology, but it is not by itself biology. And once the court adopted that, a definition, and I think it is a correct definition. I mean, with the way the law is plainly written, it says if you make any employment decision with consideration where gender is any factor, it's not like a lot of other laws. It doesn't have to be the primary factor, the dispositive factor, just any factor. Then it's discrimination. And so my view is when I read, I think, put it this way, people who think Gorsuch had some ulterior agenda don't understand Gorsuch. He's just trying to read the law as written, number one. Number two, Gorsuch is a strong critic of going outside of the text. And I agree with Gorsuch on this, because what happens otherwise is judges get to rewrite the law by saying, you know, I think this legislative history over here is what they really intended, or I think this policy consideration over here is what they really intended. And it just becomes too easy for the court to become a super legislature. And I know Gorsuch was accused of that, but he's trying to do exactly the opposite. He was saying, how broad is the law? The law says, was gender at all a consideration in the employment decision? Number one. Number two, can you say that firing someone because they're gay or transgender had nothing to do with their gender? And he's like, I can't say that. And he's like, if I could, then I would say that the law doesn't prohibit it. But it's like, I can't get around that. The other thing is, from a political perspective, I know a lot of my conservative friends are unhappy. It's good for Trump. A headline that would have been gay people can be fired just for being gay. And some of the facts in those cases were bad fact patterns for the conservative side of the aisle. I mean, these were not cases of something that was really disruptive in the employment setting. They weren't ruling on locker rooms. They weren't ruling on bathrooms. They weren't ruling on the school context. That's Title IX, very different statutory schema. They were not ruling on religious context, because there's a whole bunch of exceptions and exemptions for religious institutions, which I understand their objections. But in the context of just everyday employers, I mean, there are people who, perfect employment record, who just told their boss they were gay and they got fired. I'm just not in favor of that. Now, I have a slightly different view on this. I believe that for cause should be a limitation on all firings. I believe that once you're an employer of a certain size and scale, and cause can include economic necessity, it can include business desirability, it can include a lot of things. But my view is that most people who get a job expect that they will not be fired unless they screw up or the job or the business is failing. It gives too much power to the employer, in my view, to be able to fire them for any dumb reason they come up with. And so that's my personal view. I think down to 10, 20 years from now, we'll move to that, because we're getting into political discrimination problems that are starting to happen in different places, people being, et cetera.
People getting fired for social media posts that have nothing to do with their jobs. And it lends to not just arbitrariness, but absolute abuse, where what would have otherwise been private life that nobody would have known about now is a basis for firing. It to a lot of people doesn't make sense already. Actually, one thing though, I was tweeting, or it was a messaging with somebody where I said, I know nothing more than this, but I said any law that is based on preventing discrimination probably has some basis to be interpreted broadly beyond the specific wording of the law. So it came up in the Unruh Act, where everyone was saying that it prohibits discrimination, but doesn't specifically mention political ideology for discrimination. And I was saying, well, if a law is intended to prevent discrimination, it's going to be interpreted broadly beyond the examples enumerated in the law, which is why I was thinking maybe Gorsuch's reasoning could have been justified.
Oh, absolutely. And I think I had sort of two reactions. One was I thought he made the right legal reaction. I liked his form of statutory construction, even if people don't agree with his statutory interpretation. I disagree with Ben Shapiro and others who are saying he deviated from it. Here's the core view. My core view of judges is they should follow the law wherever it leads them. They may get it intellectually wrong, but that should be their standard. Not look for results and then retro design the law to meet those results. And what a lot of these conservatives are upset about is that Gorsuch didn't use what I consider increasingly the left's version of jurisprudence, which is hey, what result do I want? Let's bend the law to make it fit the result I want, both for the individual case and the broader public policy. I mean, it's very unfortunate to me that all four Democratic justices now are you can predict their vote based solely on the political outcome they would want from a case. That's not a good thing for the country. And so the fact that Gorsuch did something that was totally against what conservatives want to have happen, but he did so because he clearly was not governed by a results-oriented thing. And I think some of the people that were criticizing him, Shapiro and others, were really, they down deep don't believe what they've been saying. Because if they really believe in not having results-oriented jurisprudence, then their argument with Gorsuch is not that that's what he did, because clearly he did not do that. Their argument with Gorsuch is whether he got it right in the statutory interpretation. And to date, I have yet to see a compelling argument that he's wrong. I did not find the dissents very compelling. I thought the dissents were trying to go with, hey, look, back in the 1960s, nobody thought this meant transgender. No doubt about that. They probably also didn't think it meant sexual harassment either. But the law was pretty broadly worded. If they didn't want if they only wanted biological gender to be the limited factor, they could have couched phraseology that did that. And part of their objection was, hey, they've been trying to amend the law to add this, and those amendments have been rejected. That, too, is, to me, irrelevant. To me, it's how is the law written under its plain language. And if we're going to respect democracy, we respect the way the law is written. It's like the way a contract is written. And like somebody called it, it's like programming code. The programmer might not have meant the code to operate the way it does, but the programmer is bound by the code. Well, we should be bound by the legislative language, whatever that is. And if we're going to be, and that's the kind of jurisprudence I like. So I was thrilled to see, hey, here's Gorsuch taking a decision, because I've been arguing with my left friends. You can form jurisprudence that follows the law, and sometimes you'll like the public policy outcome, but you shouldn't be public policy driven, or the credibility of the courts is going to fall apart. And here was Gorsuch doing exactly that, giving a great example I get to use to say, here's an example that Gorsuch clearly does not embrace protecting transgenders. He politically has been on the conservative right his entire life, but he said the law compelled it because that was interpreting the law. And so I was very happy with the decision. I also think politically, Trump did not. If they'd come out and said it's okay, there were some horror stories there. The media would have been hammering that for a week, and it would have been, hey, this is what Trump's Supreme Court will give you. Now you can lose your job just for being gay. You better hide the fact that you're gay, or otherwise you can be fired anywhere in America. That would not. My conservative friends are misreading the tea leaves politically. They're a little bit out of it on this. They were so focused on the nightmare scenario. They were doing what they accused the left of, creating fake scenarios that aren't realistically going to happen to justify a judicial interpretation. So, I mean, there's extensive parts. Gorsuch made clear in the decision that this was not dealing with bathrooms. This was not dealing with locker rooms. This was not dealing with a whole bunch of other fact patterns. It was not dealing with dress codes. It was not dealing with anything related to religious institutions. He noted the different laws that exempt them. So all of the hysteria by some people on the right on this, I thought they should have used this as an opportunity to say, hey, here's where the law follows. And if they don't like the law, go to Congress and get it changed. That's the remedy. This wasn't constitutional interpretation he did. This was simply a statute he interpreted. They don't like it, go change it. And that's the little d democratic side of, quote unquote, the right. I mean, that used to be on the left. That used to be Justice Black's method of interpreting the law. But now it's on the right. But it's what I'm for is a respecting democracy, and that means respecting the law as written at the time it was written.
All right, amazing. Now I'm going to blast through some of these super chats here. Gary Herman says, "Thank you, Barnes. I'm from Virginia." And then we'll get into the next topic. We got John Jung says, "Ask if likely any states exclude Trump ballot."
No states will be able to exclude Trump from the ballot. There's some that were trying, but that will not work.
We got Brian P. says, "Fitton speculates election will go to court." Okay.
I understand he means Tom Fitton at Judicial Watch, that he thinks there's going to be political disputes no matter who wins. And so the courts will be integrally involved. I don't think it will be that close. But there are a lot of people who have that same interpretation as Tom does.
All right. We got Gary Herman says, "How does this decision impact Title IX and transgender in sports?" No
impact whatsoever. Title IX is written entirely differently, and I anticipate that they will not interpret Title IX to allow transgender in sports, because that's respecting a certain form of gender difference that's permissible. This was solely about whether employers in the Title VII context could discriminate against someone solely because they were transgender or gay. It doesn't even deal with scenarios where the fact they're transgender may have something to do with the firing, but it isn't the reason for the firing. They had a very limited fact pattern in front of them.
Okay, interesting. We got Nunya Biz says, any chance we get laws enacted to address the pattern of third parties attacking people's jobs and even their families' jobs? It feels like a spiteful combo of tortious interference and mob rule. It's an interesting question.
And a very dangerous one. And it's happening everywhere. I was listening to a disturbing podcast on the way back from the airport in Atlanta. Had to come back to Tennessee because there's like no flights to small cities. It's a fascinating little thing that's happening right now. We're back to where we were during the deregulation era, where during the deregulation era of airlines in the United States, it crushed all the small airports and forced everything to big airports. And we had overcome that over the last 10 years with small airports, with some supports and subsidies and other factors as well. Now, something about the pandemic effect is that the small airports are running very few flights. So you've got to basically fly into your big airport. But I was listening to a podcast by Joe Budden, who's one of the most popular podcasters in the country, Budden. It's very much, he mostly focuses on music and hip hop and predominantly African-American cultural issues of political celebrities and whatnot, very little politics. But I was disturbed by his interpretation of recent events and particularly his encouragement. Here he was from his podcast, encouraging people and thanking people for getting people fired across the country. And I was like, this guy's not even a political guy, but one, he's buying into fake narratives. He's pushing fake narratives. And he's encouraging mass mob behavior, the kind of lynching behavior. I mean, to give you an idea of how far Budden has gone down the rabbit hole, he seems to believe, by the nature of his comments, that there's a bunch of secret lynchings taking place of black men in America, and that everybody's involved in just a big secret conspiracy to cover these up as suicides, even though they conform to longstanding suicide data. But that's, I mean, when you're that far down the rabbit, and you're one of the most popular podcasters in the country, and you're not even normally political, it gives you an idea. Like, we're going to a place where people are really seeing two different films on one screen, and they're going to radically different conclusions that are really a little unsettling. But one of the most unsettling part was how at ease he was with the idea of going out and getting people fired based on their political statements, on their political beliefs. In some cases, like I've got people that I'm representing in Hollywood on TV shows who they're going after them simply because their family members have different political viewpoints. You know, if you know, under the silence is violence theory, if their entire family is not embracing Black Lives Matters and everything else connected to it, then everyone connected to them is being subject to employment risk and threat. And it is terrifying. So now some of these states where they're doing this, they're not real bright, because California, for example, does have some protections if you fire people for political reasons. I also have a theory that I'm going to start exploring, and a court has adopted it in Pennsylvania, which is that almost every state in America prohibits firings that violate public policy, but they usually just keep that very limited. My view is that something that violates First Amendment free speech standards, like these kind of things are doing, really violate public policy, and I would like to expand the laws to protect it. Like I said, my ultimate goal is to make it everything for cause. That makes it simple. You know, did you fire them because you economically had to, or they really screwed up? Or did you fire them because you just felt like being a boss that day?
Or did you fire them for the social pressure because people are going to start boycotting the business unless you publicly fire, as in a couple of recent examples? No, I say it will take one massive example of a lawsuit in order to deter this type of knee-jerk reaction from companies. Or flip side, I think it's just going to turn people off of social media, and places like Facebook and Twitter are going to be left for the 2%, but they still carry with them the digital violence that is that type of harassment. Mm-hmm. I think it'll take a lawsuit. The litigious societies have their cons, but they also have their pros. Uncivil Law says, I have a suspicion that the DACA case is a foundational case for a massive increase of the administrative state. Ask me how thrilled I am as I mutter under my breath about Chevron, Our, and Brand X.
There's two interpretations of that one because it's Roberts. You know, Roberts has been wanting to undermine certain forms of deference in the administrative state. So his decision in that regard was surprising. And that's where some of the criticism of Roberts' decision as being more politically motivated and less consistent with a philosophical approach is warranted. My own view is there were always issues with how they approached it. So I thought that there were better administrative protocols that they could have utilized to get rid of DACA. I think what no one wants to talk about is that Trump is not gung-ho at getting rid of DACA. He wants political credit for getting rid of DACA or taking it on, but doesn't want 700,000 kids deported.
So actually, it's a good time. Let's get into the DACA question, and I'll bring up the Tom Grohl's question. Because of the president of the DACA ruling, can Trump now start putting out executive orders to make it go through proper bureaucracy to undo, i.e. do it with Obamacare or national reciprocity? So 40 minutes in, let's talk about DACA, starting from the beginning. DACA is a government program and not a piece of legislation, or is it a statute or regulation, or I don't know what the term would be in the U.S., just a pure government program?
I mean, it's an executive order, but it's an executive order within the context that Congress has delegated a lot of power to the president to do. And historically, the Constitution has too. The way to think of it is it's a different version of the travel ban. And so, but it was an extraordinary expansion of the executive branch, basically doing legislation in lieu of getting it passed through Congress. So that was where the concern was from a traditional skeptic of the administrative state, skeptic of the executive branch, usurping the legislative branch. So technically all it is President Obama issuing an order that these group of people will be protected. And what he effectively did is he created an equitable entitlement. So it was always going to be hard to completely undo, because you had a whole bunch of people who then had a rightful expectation that their rights or interests could be protected. They were going to come forward and disclose their names and identities, which would allow them to be easily prosecuted and punished. And it would be one of the greatest frauds the government had ever committed if it said, hey, come forward and we're going to protect you for good. Oh, now we're going to turn around and deport you. That was always a core due process problem with that argument. But basically, Obama couldn't get through Congress legislation to protect a certain group of people. These were predominantly children of people who came here illegally, though they themselves were not all children now. There were certain restrictions that were supposed to be in place, and there was no criminal record of a serious category, things like that. The degree to which that was followed up on is currently controverted and disputed. Trump came in and tried to undo DACA, but it wasn't the most, like the first position in the Justice Department. This is all because Sessions is not the brightest bulb on the block when dealing with interpolitical warfare, in my view. We're seeing another consequence of that with the Berman case. Berman prosecutor now at the Southern District of New York. Just one more Sessions fallout. But Sessions' original view was always that DACA was never constitutional, so they were going to join the suits that was challenging DACA as unconstitutional that were already going through the courts. Then they decided instead to basically administratively undo it by the president's own orders, and claim that because it was illegal the first time is why they're undoing it now. But basically you had an administratively not a clean record. And there's some people who believe that it's because Trump wanted the courts to force him to keep DACA so he could politically argue, hey, I'm fighting it, while not suffering the consequences of 700,000 kids being threatened with deportation. And so I think that's where a lot of the issue, that's what it boils down to. Now, if Obama could create it, clearly Trump could dispatch it. And to the Super Chats question, it clearly has seemed to open up the ability to, once you pass an executive order, that people get equitable entitlement in. And actually, the first real example of this historically in America, you could argue, is the Emancipation Proclamation 1862, which was done by executive order Abraham Lincoln. And the argument was he really created an equitable entitlement in African Americans. If they escaped into Northern custody, they could be free. Could he have undone that if the 13th, 14th, and 15th Amendment had never passed the U.S. Constitution? So it's a variation of that. The executive power has always been there. The question has been how much outside the legislative process can they go before they're just usurping the legislative prerogative, and how much will the executive, as uncivil law mentions, giving the executive power ends up being an administrative power entitlement that causes a whole range of issues. Because what happens is we get these bureaucrats who aren't elected by anybody, they aren't appointed by elected officials, like Berman up in New York. Here's the head of the most important prosecutor's office in the country, never been approved by the Senate, was not directly put there by the president. He was put there temporarily by Sessions, and there's this temporary provision that allows a court to put him in, and all of a sudden he's declaring nobody can remove him until the Senate removes him. That's the kind of danger we have with administrative state excesses. So I'm not a big fan of the decision, but I think I have a contrarian take on it in that I don't think it will have long-term institutional consequences. I do think Roberts was making a political decision, that Roberts didn't want to be the guy to undo DACA. And I think that contrary to conventional wisdom, it benefits Trump because it allows him to campaign against DACA without actually having the consequences of 700,000 kids being put at risk, which would have been a political nightmare for him in an election year.
So that was one question. So 700,000 kids who probably, it's been going on for 13 years now, DACA, or was it?
No, just since 2014. So about 6 years.
That was totally silly. So 2016. So, okay. So they're only 4 or 5 years. So a lot of them might not be kids, but it doesn't matter. Under DACA, they were protected for a 2-year rolling period.
Yeah. And so it varied. But the real core to DACA was, if you tell us your name, we'll never deport you. That was the real, in my view, that I think that's what the courts were always going to be concerned with undoing DACA. Because we have the president of the United States telling all of these people that if they come in and provide information about who they are, what their names are, what their identities are, get their identity, get their fingerprinted, get photographed, whatever else may go into that, that nothing bad, you'll never get deported. And so it's impossible to reverse DACA because that's always going to be a problem. These people are not going to be deported. Anybody who thinks that is just in the political naivete, legal naivete. And in my view, they should have come up with a better solution. Now, Trump did try to work out a solution, but Democrats have no interest in it. The Democrats' interest is in using it to bash Trump over the head. And Trump isn't really that interested in undermining it without a solution that protects them, without the concern of the Ann Coulters of the world. Is that when you do DACA, there's going to be another DACA, and then there'll be another DACA, and there'll be and what it does is it invites people to come illegally, because they're like, look, all we got to do is hang around long enough, and some politician will give us a green card, will give us citizenship, because that's what happened. It's what Reagan did in the mid '80s, and that just led to another wave and another wave, and that's a fair criticism. But once this was done, it's very hard to undo it. It definitely, both the uncivil laws question and the other super chat question, it's going to encourage presidents to use this more in the future. And that probably will open up a few Pandora's boxes that we will regret. And probably 10 years from now, Roberts will fix it. Yeah, it would be like him to fix it. But right now he can have his parties in the Hamptons this summer and not feel bad.
But so it protects the children. Stupid question, and maybe it is. What happens to the parents, or what has happened to the parents? Do they become citizens, or do they get deported or go back?
They're generally not protected, but as a practical matter, they haven't been doing anything that with someone who's a parent of a DACA child. Okay.
And now, from what I understood, the difference between DACA and Dreamers was that there's no path to citizenship under DACA.
Right.
So I don't know what was the plan. I'm not trying to play political blame game.
Theoretically, it was just the real goal was simple. Just by promising them that they disclose their names, they won't be deported. It was really permanent protection against deportation. That's what it functioned as. They didn't pitch it that way, but that's what, if you looked at it, that's how it was going to work. Now, how it was intended to work publicly in terms of the promotion, it was to bring these people out of the shadows into the light, get them work visas, get them part of the tax-paying system, with maybe a potential for citizenship down the road. But that was how it was pitched by President Obama, and he pitched it as he was just not going to prosecute. He was going to exercise his discretionary authority over where the Justice Department and ICE chose to prosecute cases, and he pitched his legislation as not really legislation, just an executive choice. That was never really that straightforward, because it created equitable entitlement in these people's minds, that it made it impossible to reverse.
Equitable entitlement, we have a concept called acquired rights in Quebec. I mean, it's basically once they have the right, you can't just take it away.
Exactly.
Okay, and the way you explain it now, I can sort of understand the rationale in that the flip side is if you take it away, they were duped into disclosing their identity, whereas now they are targets. Whereas, but in the absence of DACA, they could have at least not disclosed their name and hidden more easily. Now it's like sort of like a firearm registry in Canada, whereas if one day the government says no longer legal, we know exactly where to go, which is odd. You know, the Canadian government is in the process of doing that, but with humans and with kids especially, you can understand the rationale as you want freedom, you want them to go to school, you want them to potentially work, pay taxes. Just seems like a silly thing that there was no long-term path to any sort of citizenship built in. When it goes by way of executive order, now I understand executive orders have to be constitutional in and of themselves. It bypasses the legislative process because you don't require legislation. What's the question with this? So what is the limit on executive orders for things that are constitutional but not passed through ordinary legislation?
Well, according to Justice Roberts, it's compliance with the Administrative Procedures Act. So so that somehow he dodged whether the first executive order was okay by just saying, well, the second executive order wasn't okay because it didn't comply with the Administrative Procedures Act. So it was, I had a hard time taking the opinion at face value. It was so political in my view. And this was something where Roberts has been one of the strongest criticisms of the administrative state. So he's wanted to undermine the entire deference doctrine almost entirely. He's been working on it for years. So for him to go this route never struck me as a particularly credible path. I saw it as a temporary political decision because he didn't want to have the court in the middle of denying 700,000 kids, putting them at deportation risk. I remember years ago, there was Justice Black told someone, and I think it's in the book, The Brethren, a great book by Bob Woodward about the U.S. Supreme Court, where Black was telling one of his clerks that they were going to agree to suspend the death penalty because he said justices couldn't handle the idea of blood on their hands otherwise. And he was predicting that it didn't have anything to do with the law. They just were not going to greenlight a bunch of people dying over the summer when they could suspend it for the summer. And he was turned out to be precisely right. So I think that's what happened here. I think Gorsuch got unfair criticism. Roberts got, I think, legitimate criticism for what he did.
Okay, interesting. We're going to see if I can get through some of these. 420 Atheism says the concept of gender was invented through a failed child abuse experiment by John Money.
I honestly cannot speak to that.
Nor can I. Burning Straight, I agree with Barnes 100% for obvious reasons, but how much should it cost for employers to choose who they associate with? I say the courts will settle it at some point. It's and
my general take is, like, it's my view on minimum wage. I have a more democratic view on that because my general view is if you're running a business that can't afford to pay people enough to be able to feed and house and clothe themselves and their family on, then you're really not a successful business. That's my view. So and it's the same thing here. It's like you should be able to choose who you associate with for business based on the business. Nobody requires you to hang out with them. Nobody requires you to go to lunch or dinner with them. Nobody requires any of those things. And I just don't like the idea that just because, that because someone's gay in particular, and there's not going to be many. The reality is there's very few transgender people in the country. So that's just not a practical issue for most. I represent a lot of employers. It's not a practical issue. And and the reality is knowing they're gay is not going to impact their job or their business. And I think we create more harm than good by allowing discrimination against people because they're gay, in my view, in terms of policy.
Okay, interesting. I tend to agree with that as well. Tony Nieves says possible suit against Sky Jones doxing children on her Twitter to thousands and millions of followers. I know what I'm looking up right after we get off of this live.
She's doing it all over the place. I've been tracking her, was trying to discourage her from doing so. But then when I realized, like I said, Joe Budden is out there pushing it, I was like, man, this is a cultural issue. Now, as a practical matter, most of what she's disclosing is people's social media accounts. So that now, where she's going further is when somebody leaks private video. That's going to be a different dynamic. People should look back at the sex tapes that have been illicitly released. Where Pamela Anderson and others have sought and successfully obtained some legal remedy frequently. So if what they're leaking is private, very different than if it's public. Now, some of these people are minors, 16 or 17, but it's their own deliberately, voluntarily produced public social feeds in most instances. I can tell you right now, the courts don't even recognize doxing as a claim yet. I'm trying to get that established in the Covington case. But the Covington case has more sympathetic facts factually and legally than right now some of these other people do. I think we're going to need to pass a law to basically preclude it, to put some limits on social media behavior without getting into First Amendment areas. So that would be the tricky part. How to protect people from this kind of doxing for censorship and firing purposes, while at the same time not discouraging First Amendment activities from taking place.
Yeah, no, it's the balance, and it's the thing. If you have kids, that you have to have the discussion with them early, because TikTok is all fun and games until one day you decide to put up some political TikTok that you can never get away from for the rest of your life.
Exactly.
Dave says, I'm for DACA, but from a legal perspective, how can SCOTUS go against an EO? On its premise, aren't they discretionary? Goes against separation of power.
Oh, that's true. Essentially what he did is he found a technicality. He was like, hey, yeah, you can do this, but you missed the paperwork on page 7. That's the summary of Roberts' decision. There's no other way to put it. There was no grand principle there.
Okay. Does Roberts think the stepmom of the cop who got fired is going to sue, or would she possibly even have a case?
It depends. I mean, her employer put out a very aggressive statement that if that statement is wrong, then she could sue for defamation and libel. They claimed it had nothing to do with the relationship. Whether that's true or not, we'll see. But if they're lying, then yeah, they can be sued for libel. They opened themselves up to suit by making those kind of statements. That may be the case. Well, I won't mention the case, but that may be the case in some other high-profile cases coming out soon too.
All right, I'm going to read Life of Brian, which is more a comment than a question. 2 questions. How can the non-left win if the left is the only side that cheats? 2, how can this not have the effect on dress codes if a man dresses up as a woman at work? Okay, dress codes is interesting. I hadn't thought about that, actually, but...
Yeah, because that was technically the most sympathetic case was the transgender case, because it was a funeral home director. And the funeral home director had people dress conservatively because it was his view that it would be traumatizing to people to see anything out of the ordinary at their funeral event. And so when this person who worked for him came to them and said, hey, my psychologist has told me I need to act as a woman moving forward and dress accordingly, he thought about it, and he even wrote an op-ed in the Washington Post about it. And he's like, I just don't think that, I think that will undermine my business. I think it will unsettle guests too much, and thus terminated him. Now, the thing is, he didn't make it a dress code issue. In other words, he didn't say, what he said was, hey, you're transgender, I can't have transgender people here, though he was thinking the dress code issue. So he ended up limiting his facts. They also had some other arguments they could have made, but they'd waived them by the time of the Supreme Court. So that's where some of the issues there get unresolved. But because here's the way to put it. Could you have a dress code without consideration of gender? The answer is probably yes. So that's the way to think of it. Now, if you made your dress code gender specific, what does that mean? Right? But like, for example, if you say, I don't want people to dress in a way that's for example, the question is, would gender appropriate dress now be an issue? Gorsuch went out of his way in the decision to say, we're not dealing with dress codes yet, saying this decision does not change dress codes. So it's going to be something they're going to have to deal with. My own view is they should just change the legislation and make it for cause, and cause could include dress code, because dress code compliance for marketing purposes, business. This goes back to the Hooters debate, because there are some women who sued on the grounds that just those outfits were sexually harassing. Might be true, but that was part of their whole marketing appeal. It wasn't about the owl, folks. So we'll see how it develops and unfolds. But yeah, it is an issue, but it's not that part's not yet determined. And my view is the solution is legislation, not force the courts to rewrite the law.
Okay, very interesting. I'll read this one here. Mandalore Y01. Could lawsuits be brought against Facebook, Twitter for tortious interference in contracts if they lose the platform protection?
If they lose the platform protection, yes. And to his credit, praise goodness, Senator Hawley finally came around. He'd been pushing every other proposal known to man. 2 years ago, I proposed a very simple solution to him and others, which at CPAC and at other locations, which was, look, just make Section 230 contingent upon being First Amendment compliant. It's that simple. So there's not a single social media giant that won't take that trade-off. All the libertarian concern of, hey, you're trying to impose on Google's free speech. No, because all you're saying is, if you want this special carrot, there's a stick that comes with it. And if they did that, then if they were deliberately discriminating against people for First Amendment violations that has a tortious impact on their contractual relationship or economic relationships, then yes, they could bring suit. So, but the key is Hawley's bill passing. Right now, the courts are closed pretty much.
Okay, now I saw a super chat from Nate Brody, which I think I must have just skipped over.
By the way, I do recommend Brody's review on the Atlanta case. That was another disturbing thing. So I was listening to Joe Budden, and he basically, you wouldn't have known. Here's the story. And I was hearing one of the most popular podcasters, not a very political guy, telling his whole audience, millions every week, that basically the story you would get from him, from how he described it, is that, hey, he did the right thing. He wanted to sleep it off, so he decided to sleep it off in a nice Wendy's parking lot. That's where people are encouraged to. And he just wanted to go home. He was willing to walk home, and the cops shot him in the back twice. And his family was waiting for him, and his daughter's birthday was the next day. And I was like, are they even going to mention everything else that happened? Are they going to mention the guy's a wife abuser and a child abuser, and this is not the Family Man of the Year award guy? No, that does not exist. And Joe, in fact, he got angry when he was describing "quote unquote" white people having a different opinion about anything related, about white people complaining about looting, that somehow that was a bad act and they just don't understand what's happening. This nonsense about this is the streets. This is not the streets. This is a small percentage of the community, and it's racial stereotyping. It brings to mind the whole purpose and the real impact of Ralph Ellison's book, The Invisible Man. Because what that was revelatory to me about when I read it as a kid, aside from the unique genius of saying you got to curse them with your yes sirs, which is fascinating. That's a whole nother dialogue. But the independent of that was that here you had a man who could never be seen for who he was as a human being, could not be seen for as being a man. He could only be seen, and while it's heavily allegorical and heavily metaphorical, and that can be difficult, a dense text to make Shakespeare look like an easy read, make Shakespeare look like Cliff's Notes, but still genius. And he's describing the extraordinary frustration that no matter where he turned politically, culturally, or economically in America in the 1950s, he could not find anyone as an institutional group that could identify him as a human being. They could only see the color of his skin. And it's unfortunate that people like Joe Budden and others are now doing that exact same thing. And because Nate just did a great breakdown, and I would even add a second component to that, the Atlanta case. Now, I have a slightly different take, just because when I first watched the video, my instinctual read, and this is highly speculative and by no means evidence in a court of law, was that it was a retaliatory shoot. It felt like that. Now, again, that's just watching 2 seconds of video. But it felt like that. And what I told people is what I always tell people is, if I'm right that it was a retaliatory shooting, you're going to find that the cop involved had a bad history of civil complaints. And then, of course, turned out the cop did have. He's 27 years old, and he had 11 complaints against him. I know there are a lot of excuses on that from people on the right, but I can tell you from doing these cases that is very abnormal. That's usually the sign of a
one of the comments I noticed from the last time we discussed this in George Floyd, some people said, well, 11 complaints are different. Complaints are not cases that are brought up for discipline. So that doesn't necessarily mean anything.
Yeah, and I know they think that they're wrong. The average cop will have had no complaints. Remember the Michael Brown case, 7 years on the job, 0 complaints. The most people never complain about the police. Even people that are upset about the police often just won't complain about it. So in my experience, less than 10% of cops will have any complaint against them. Less than 5% of cops will have double-digit complaints against them. And those cops will end up doing something bad at some point. So, the main fact that the DA has on his side, if he's right about it, is that the taser was no longer a weapon. And he claims that the police officer who shot him knew that the taser only had 2 charges in it and that he had already used both. And that thus he shot him in the back twice. That's the other problem, shooting him in the back twice, knowing that he no longer had a dangerous weapon because the taser was no longer charged or chargeable. So that was now here's the problem for the DA. There's a second component that Nate didn't go in detail on, didn't need to, but he was citing the right provision because he's right. This will all come down to their training and what the Atlanta Police Department authorizes the use of force for. The one provision says if the person has a dangerous weapon, then you can use, and is fleeing, then you can use force as a police officer. But the other one is if they have attempted to commit a violent crime and you believe they are maybe a danger to someone else, then you can also use deadly force. And here, according to published reports, they knew about the reason why they approached him the way they did is they knew about his entire history beforehand.
They ran the plates before they go to make the stop and then have an idea.
Correct. And they knew he had a long history of violence, violence against women, violence against children, violence in general, fleeing officers, so on and so forth. So they know that he's a risk of that kind of, and that's part one. Part two, they just witnessed him commit a violent crime. So here's what the prosecutor's theory is going to have to be. His theory is going to have to be that it's going to be like the Arbery case, that the original arrest was invalid and that thus he was defending himself when he was trying to escape the arrest because the arrest itself was invalid. Because otherwise that was criminal behavior. He committed violence against two police officers. Not only did he get away from them and physically assault them, he then got the taser, tased one, tried to tase the other. There, the DA was just being misleading. I've seen some other people be misleading. CNN had some lawyer on saying a taser is not a deadly weapon. The Georgia Supreme Court, as Nate outlines well, just last year said absolutely it's a deadly weapon. That's already been litigated. The DA a month ago said it was a deadly weapon. So why they have to lie about these things drives me crazy. They make all my civil rights cases harder. And as someone put in a comment once, they're like, well, that's not making your life harder, Barnes. I'm like, yeah, you're right. It's making my clients' lives much harder. They're the ones not going to get justice now, thanks to these politicized, racialized reinterpretation of events that often pushes lies rather than truths. It's going to be African-American children, women, family members of people bringing suit who now will not get remedy because people like Joe Budden want to feel good about themselves and tell false stories to their audience. And it's frustrating to me, and I have little sympathy for them. I mean, when they want to get on their moral high horse, none of these guys show up on any case that I've ever seen of anything in their local hometown. It's my complaint about LeBron James, it's my complaint about Malcolm Jenkins with the Saints, who's all mad about the flag. All suddenly, I mean, all these guys can go to their small hometown, find a legitimate case, a civil rights case. I guarantee you there's at least one, and they can provide public attention to that case that will lead to real reform in that local community that will protect people's lives moving forward. I've asked these people to do it in different contexts and cases, and they almost never seem to show up. So I just don't have a lot of esteem for them. And in fact, when they're making civil rights harder to obtain by telling fake narratives about people, because again, in my own view, I have doubts about that cop in the Atlanta case. My instinct is that he didn't shoot him because of those other reasons. They may be a legal justification. It felt like he shot him because he was mad, that he wanted revenge. Understandable why he wanted it. He just tased his buddy, tried to tase him, ran away from him, assaulted him. I understand it. But that's exactly what the Supreme Court said he couldn't do. That can't be his basis to execute deadly force. But I also understand why people were mad about how the case was portrayed. The DA was the DA just lied to he went out and said, oh, he was totally cordial and everything was cool. And it's like, no, just admit the truth and deal with it.
I mean, that's the amazing thing. And I actually will describe it just from the beginning in case anybody hasn't seen it. But one thing, Nate's other question came up. Are the DACA recipients essentially U.S. nationals like American Samoans?
Kind of. I mean, by Obama's order. In other words, the real effect was it would be hard to ever do any harm to them once the president of the United States told them they'd be protected if they came forward. That's the ultimate takeaway. Legally, they're always in this nebulous position because whether the order was lawful from the get-go is still in doubt. I mean, they never said the DACA decision was constitutional. Hold on a second. Oh, yeah, there we go. Sweet.
Okay. Okay, now give me 1 second here. Mandy Amos, I can't pull it up. It says, Mandy Amos, why are my super chats limited to 50 characters? First of all, Mandy Amos, was that your name before the video that I did, or is it just a total coincidence, or did you change it? Because you might have to change it. I think the characters are limited depending on the super chat, is my thought. Any recommendations on someone trying to survive in corporate world where if you don't support BLM, you're being called a racist by the CEO? This is a discussion more theoretical than legal, which...
I mean, the advice I give to people, I'm like my daughter's in the fashion world now. She happens to be on that whole BLM train. Because it was fascinating, the whole young generation, because I think now more than ever of hip hop's influence and shaping their curating their cultural viewpoint is why they've reacted the way they have, in my view. But I've told people that were in that position, even that didn't have that politics, I was like, just decide what price you're willing to pay. I said, on the one hand, there's always risk once you start going down the line of making little compromises that you end up selling off your soul to where you're unhappy and unsatisfied with your accumulated decisions. At the other hand, sometimes there's better hills to die on. So I think, but a lot of people are having to make that difficult choice. And if you're in Hollywood, or if you're in the fashion industry, or you're in certain cultural places, you have to be on that side. And so what I've often told people is find the place where you agree. Maybe don't agree with BLM, but find the place where you overlap an agreement where you say they would agree with, and highlight that, because that can be consistent with your principles. You're not sacrificing your principles without putting a big target on your head. Only a few of us really can, without economic consequence, voice our true opinions, which is unfortunate, but it's the reality today.
And incidentally, that's one of the negotiating tactics where they said, agree when you're negotiating, agree on the small things before you fight over the big things. Mm-hmm. Now, I'm going to read this and I'm going to make a comment afterwards. Politifiction says, please help. I was a speaker at a rally. The mayor slandered me and I was fired from my job. I sued, was dismissed on a 12B6, just like the Covington case. I'm unemployed. Contacted Falk, but no reply. This is my last $20. I don't want to feel like an Elizabeth Warren moment, so I'm going to see how I can refund this super chat if I can, because I'm not taking your last $20, Politifiction, so I can read this comment. So I'm going to try to do that after the stream. What do we say?
I understand. I mean, I've had tons of inquiries about a range of cases. So for those that have already been dismissed, we can look at a potential appeal, and that's what can happen. In all of those cases, there's more high quality cases than I can handle. And particularly almost all of these cases, they're seeking pro bono representation. And I was up at around 50% pro bono last year. I'm on pace for that same this year. I could do that if I was my own thing, if no one else relied upon me to monetize my skill set to support being able to feed their families, but that's not the case. So I am sympathetic with everybody who makes inquiries. I will be reevaluating from time to time when I have time to see what other cases we can handle on a pro bono basis. I understand everyone has, they reveal the need for it, and to be frank about it, the more Free America Law Center support there is, the more I can get other lawyers involved because I can pay for their time. But right now, Free America Law Center doesn't even provide enough support for the cost of the Covington case. So that's just not a realistic option. And I have a little bit of the criticism on the right, which is those of us who have created the opportunities on the right to counterbalance, to provide some voice for people that the ACLU is ignoring and the people on the left are ignoring because of their politics. The reality is people on the right just do not back legal cases. So, if you're Andrew McCabe and you tell a fake story about why you're out, you get $650,000 overnight. If you're General Flynn, one of the most highest targeted people ever, you still don't have your legal bills paid. So it's the people on the right talk a lot, but they don't actually put their money where their mouth is. So it's always been a problem. And what tends to happen is the people on the right end up being co-opted. I created Falk so that it was based on one-time donors and monthly subscribers because I did not want it. I was not going to be running the organization over time, but I wanted the institutional structure to be such that it would not be susceptible to big billionaire sugar daddy takeover where you're really doing someone else's agenda, not the public's agenda writ large. But as a practical matter, until and unless we group our funding and get more lawyers on board to do more pro bono work, and I've reached out to a lot of people, and many have, to their credit. Harmeet Dillon is doing a good bit of this. Ron Coleman is. Kurt Schlichter is. But, the reality is the legal profession is overwhelmingly to the left. So, they came out of the woodwork to pay for bail for rioters and looters. And not only that, they didn't need to pay legal fees because they were offering pro bono representation by lawyers all across the country. The right is badly underrepresented in the current political environment. But the only way that's going to change is if one of two things: either more lawyers agree to donate more of their time, or the public comes together to support monetize them at a mass basis. So we will continue to try to represent everybody for free that we can. Right now, we're up to the max.
All right. And now I missed Kelly Graham, $50 super chat. Thank you very much. And it says, just because I'm really enjoying listening. I can't pull up the actual chat to read it. And now Vicky Rose has a chat and is going to get us into the discussion. How is it okay for the media to either show clips or only report parts of the facts that end up being misleading about a case, especially if full tape and more details available? And on that same idea, let me just get to the next chat, which I saw here. Tasers can be used over 100 times on a single charge and can be used after deploying the barbs from Zuhu. So this is the thing. Like I heard about the case because we were, in the wake of George Floyd, and I hear about another case. I hear the way it's being described. I hadn't seen anything yet because I was a couple of days behind. Then I see a portion of the video, which is the only portion, 2 seconds, individual running and getting shot. And then I think I have a better understanding. And then 5 minutes later, after looking into it, there's an entire video. And it's just to say that it's radically misrepresented. And it's not to say that when you describe it this way, it almost sounds like you're saying you're finding a justification already. Where right now I'm saying I just need all the information before I can formulate an opinion. In George Floyd, once all that information came out, it didn't change anything. In this situation, it wasn't a George Floyd, and it was being depicted like that in the immediate aftermath. And then you see the video, a 2-minute altercation or a substantial altercation, disarming one of the police officers. I don't know where he was shot, that he was shot in the back, and I'm trying to, visualize how that could happen with pointing a taser at a cop while you're running away. The idea of shooting someone as they're running away is another problematic issue. Mm-hmm. But to go from the initial description to the actual scenario, and then getting into the violent history of the individual, where in George Floyd, people were bringing that up. And I was saying, okay, and Candace Owens, and I'm saying, okay, the violent history can be relevant if it's relevant to the immediate incident, where it wasn't obviously the case in George Floyd, if at all. In this particular case, it could be determined in terms of how they approach the individual and then seeing how he reacts. But in getting into it, how can they get away with misrepresenting it on the media? It's almost par for the course now. There's no legal repercussions, despite the litigious society that is the states. And so it's just a question of not enough people taking issue with it. And I think an even bigger problem is not enough people even realizing it, and then being satisfied with what they think they understand, not knowing what they don't know, and then formulating a radical opinion that drives what we see today.
I mean, the only people who could sue would be the police officers themselves on grounds of defamation or libel. They would be hard cases, and they're not likely to bring those cases while they're facing criminal prosecution, because they would be subjecting themselves to civil discovery and a bunch of other things. So that's why the media can get away with it. And they always will. They like, now what I tell people is, like what Joe Budden said, for example, on his podcast, I was like, all of these media statements would never survive in a court of law. Like when I was in the court on Friday, there's even some of my clients wanted certain ideas voiced. And I was like, well, we have to have evidence for that. And I was like, a lot of this we just don't have evidence for. It's what's admissible evidence. And the media would never be able to get away with what they get away with if they had to have their information tested in a court of law. They would fail every time.
Yeah, and what was I about to say about the way it's depicted? I got distracted for a second because Mandy Amos just confirmed that she changed her name after that video. How could she not? So people have this understanding. That was the question. So now, under the law, and if we see Nate Brody's video, we broke it down under Georgia law, and like Robert knows as well. Just recently, they confirmed that tasers are a deadly weapon. Not that you needed that confirmation, but it certainly helps understand, because people have been tased to death, literally, and criminal charges have followed. So knowing the full incident now, who was it that resigned the day after?
I'm not sure. I mean, I'm not sure if I didn't think either. I thought the officer might have been removed right away.
No, I think it was the mayor. So someone, one of the politicians resigned the day later after the shooting. I couldn't understand that. Maybe someone's going to give me the name. That
part I don't know.
Okay.
If it's the case that for whatever reason that particular taser, that the police officers knew that once he fired it a second time was no longer a weapon, then that is a potential evidentiary issue for trial. But what I found fascinating was but they have a second argument here. I mean, the second argument is that he had just committed a violent assault, and they had every reason, given that they also knew his history, to believe he would commit another one if they didn't stop him. I mean, the other example I give, I gave it during the Arbery case too. I was like, if you think in your head that someone's very dangerous and they're about to get away because of what they've already done in terms of assaulting you and using the taser to escape, and let's say they go kill like a 8-year-old kid, isn't everybody going to blame the police officer for not detaining them? So by any means possible. So I still don't like the 2 shots in the back. Well, you couldn't aim for the leg. The rest, I don't like his bad history. I still have doubts about what was going on in his head. But I definitely did not think it was a rush to felony murder prosecution. That was a very politically motivated decision. And then when he lied about it, everybody in the media is lying about it, and people, on podcasts are lying about it. I was like, this is getting really out of hand.
No, and I wouldn't. Me, I don't use the word lie. I would say misrepresent. Maybe they don't know any better. And, it's like sort of that willful ignorance of Jimmy Kimmel type thing when he makes a joke. I don't believe that people with the team would be unaware of certain fundamental facts.
Right.
But
particularly the DA. I mean, the DA knew better. And it's like, why even put that out there? I mean, it's not something that's going to hold up in time. It's just, here's the backstory. The DA has a tough primary campaign from someone challenging him from the left in Fulton County. So that's what all of this is about. It's the coincidence of an election. But you had a serious chance of half of a police force walking off. I mean, they were seriously thinking about it. Imagine what Atlanta would look like with no police force. It'd be Chaz. It would be a Dear Chaz land on steroids. I'd have been flying into some other airport, not Atlanta. I don't need to escape from New York or escape from LA. I love both movies, but I don't want to actually go through that myself unless they make me the king. If they make me the warlord, maybe I'll think about it.
And what I find disconcerting is that the examples now of police brutality, police excessive force, they're going from George Floyd, unarmed, by all accounts, not any meaningful resistance of arrest, handcuffed with his arms behind his back, 9 minutes with a guy's knee on his neck, to, and I can accept that as the personification of police abuse. And in that context, his criminal history was less relevant for me than it was for other people. It was not relevant for me. And then we get to another case where it follows an altercation, assault on the police officers, disarming the police officers, fleeing with a taser. The fact that the taser can only hold 2 charges and the cops ought to have known that 2 charges were done, I'm not sure that anybody's brain is working that meticulously under such circumstances.
Especially that tight time frame, right? And in the heightened emotional context of, especially because he acted so cool. It was only when they started putting the handcuffs on that he did violent resist. I mean, he waited for the right time because he managed to get away from 2 cops and get one of their weapons and use one of those weapons against them. You don't see that every day.
No, and that this becomes the poster example of police abuse, where you're going to have other police saying, how far does it have to go before the public will allow us to discharge, do what we have to do in order to protect ourselves and the community. So it
seriously demeans what happened in the George Floyd case. To make all of these George Floyd is disparaging to George Floyd's legacy.
Yeah, I mean, and if you haven't watched Nate Brody's video, go watch it. It will open your mind and open your eyes if all that you've seen is what you've seen on the news. Okay, let's go. Best DJF. Oh, and we're going to get into Chaz and Chop because it's the perfect segue. Fashion industry depends on the government. It's all liberal arts, there is a good reason why specific demographics supports these movements. Just found out who benefits and follow the money. And let's see what else we got down here. Chaz and Chop. Yeah, they went from one acronym to a less fortunate acronym. Oh, there's been quite a few. Let's just see if we can do this real quick. Mr. History, you might be a bit behind on info in the Floyd case. He wasn't being choked. His heart was failing. Police were following proper protocol for excited delirium. I'm not sure I'll agree, but I'm going to certainly look into it. I know what the first coroner report said, and I don't think I'm behind on the news, so I'll look.
Basically, there's an argument made in a Medium publication that argues that he was complying with Minneapolis's requirement that someone with excited delirium, that they contain him and not allow him to move until paramedics arrived. So that apparently is going to be Chauvin's defense. That the reason why he's still on him, even when he's not moving or anything else, was because he was following the unique criteria involving excited delirium two pieces of evidence that may favor him in that regard is the peculiar disappearance of Minneapolis's police department policies not from its website not long after this. They found him in some other locations, but that is a little bit odd. But by the way, if that was, as Nate Brody and others have explained, if that was actually Minneapolis's policy, that's a serious problem because every other police department has gotten rid of that policy. That doesn't have that policy. They've gotten rid of chokeholds for the most part. They've gotten rid of most neck restraints. They understand the risk with this. But my counter to that would be twofold. One, Chauvin had 18 prior complaints, including many severe complaints involving improper use of lethal force. Again, in my experience, that suggests this was not for good purposes, and then that he wasn't just following procedure. And then the second aspect is he was about to plead guilty to third-degree murder. So his reaction was not, hey, I was totally innocent here. At least I've rarely seen that from police officers try to plead quickly to a case unless they believe that the evidence will make their case look worse as time develops. That's when you rush to do a plea that's going to put you in prison for 20 years. It's because you believe the other side's going to get evidence that's going to show you should belong in prison for life. In my interpretation. Now, the case could mean other things, could mean that he thought he was up against it, et cetera.
Okay.
But yeah, I understand other people's views, but I do still believe Chauvin will be convicted.
I mean, as do I. If I do wonder what sort of negative impression it's the bystanders who are describing what's going on in real time with little to no processing by Chauvin. It's not even in the Tony Timpa. The police looked a little more genuinely concerned for his well-being and were looking out for him, even though totally incompetent. But in this case, I mean, it was being told in real time what he was doing was killing the individual and didn't change the slightest. It was the police chief that resigned in the Rayshard, which it just seems political. It seems political just from a legal perspective. It seems politicized from the global perspective, or the environment right now that we're living in. Do we get into someone says I misrepresented the plot in Rashomon, SDFU. I did. They all witnessed the same violent act and they all had their own different versions of what they witnessed. I'm going to go back and watch it because it has been a decade since I've watched it. So maybe my memory is rusty. Okay. So we're at an hour and 26. One last topic. We'll do Chaz. Okay. I mean, someone asked me what about these property laws and all this stuff? I don't even know where to start with this. This seems like Mad Max. And the only thing I can take credit for is, or not take credit, the only thing I can say is when it was the mayor who said, it resembles a block party in her interview with Cuomo. I said, this interview is not going to age well. And given the news that came out just yesterday, where there was a murder and someone's in critical condition, tended to, and the article said they were brought to the hospital by CHOP paramedics or CHOP. I was like, what is it? What are we living in? What's going on, Robert? I mean, it makes sense to those who can't understand it.
There's some people that have wondered about whether there's any action against the government that can be brought. The general answer is no. There is something called, under the substantive due process provisions of the 14th Amendment, because generally due process just protects procedure. But there is a substantive provision that protects your property or liberty from the government creating. It's what's called a state created danger doctrine. That is unlikely to apply here. Otherwise, there's no duty to protect by a police officer unless that arises by some specific custodial relationship or an order of protection being put in place by the court in certain instances. Now, what you do have is an ongoing private nuisance. So you could go to court if you're one of the property owners or business owners and say, and have the court order the police to go in there and clear everybody out, because it's a constant private nuisance. That's the only, when I was looking at this for people who are asking me that's the only legal remedy I can see right now. Otherwise, unfortunately, what people assume is the case is actually not the case in terms of the duty of the police or the duty of a city to protect property or people. That's
what you need to flesh out, because I know I read the case. I don't remember which one it was. I remember the details. There is no duty to protect by the police. People are going to be shocked, but can you explain that principle?
Well, I just had 3 cases up before the U.S. Supreme Court. I knew they weren't going to take the qualified immunity case at the end because they refused to take any of my cases. And 2 of the 3 involved this precise issue. And one of them, and it was circumstances that were more compelling. So like in one case, somebody was institutionalized in a state mental health facility, and they gave him the very tool to harm himself that he was put in that facility to prevent. And the court, the Seventh Circuit Court of Appeals and the Federal District Court in Wisconsin said, no duty there to do anything other than what happened. Same thing, I'll give you another example. A city of West Bend created a little park using taxpayer dollars, getting themselves reelected based on creating that park. They create the park. They even charge people to use the park. They encourage working class people in particular to attend the park, to go to the park. That's the community's mostly working class. And they tell them that it's safe. They tell them there's a swimming area that little kids can swim in, that they have safety provisions in place and lifeguards in place. Well, a little girl went there with her family, ended up drowning. They only found out when somebody stepped on her. They didn't use any of their lifeguard procedures that they were supposed to, that none of the protections were in place. And what did all the courts say? No problem, no duty. So even when they created the park, even when they created the pond ended up being murky. It had secret drop-offs they didn't tell anybody about. They basically created a danger, literally. They still said that wasn't a, quote, state-created danger. So they've limited that so restrictively that there's just no way to sue. The way to think about it is, if you could sue in Seattle for being one of those homeowners or business owners, then you could sue for being in the south side of Chicago the last 4 years. Because there's been ineffective policing, ineffective politicking there with the death rate that's taken place. So maybe it should be different. And there used to be different rules. For about 200, 300 years, America had riot laws, for example, at least, that required them to, most cities did, that required the city to, if it had a police force, it had a duty to compensate people who were had any property damage whatsoever during a riot. Definitely in New York, New Jersey, other places. But they got rid of all those statutes in the late 1960s. Some believe in order to enable riots to occur. But the net effect has been, if you're a cop or you're a city, the only way you're going to get sued is if you go in there. If you go in there and cause anybody harm and upset anybody, they might sue you for excessive force. But the people actually getting harmed in there have no protection whatsoever and no remedy for the absence of protection.
I mean, that is the ultimate irony, is that it absolves the government of all of its obligations. It makes it immune and creates no obligation to actually do the job well or properly. Elect someone else, and then maybe they'll do something different. Scotty Rammer says, as someone who's been in combat, it's almost impossible to maintain a level of knowledge of how many rounds have been fired. I find it disingenuous of the DA to use that as an argument against the cop. I would tend to agree. It's not like, first of all, thank you very much. But I would tend to agree. It's like, you get into a zone, you can't know how many charge. And I'd be curious if the taser actually only carries 2 charges, because that doesn't seem like a very effective taser in the first place.
Yeah, I'd be curious about that. I'm curious about, assuming that kind of intent under that compressed time frame. But also, again, that in Atlanta, that there was a second provision. If he had just committed a violent crime or tried to, and they thought he was at risk to do it again in the near short-term future, then they could also use lethal force. So they have a high likelihood of being acquitted.
And then it gets back to the issue. Sorry, I'm not even saying your name here. I tweeted a screen cap from the Brooks video, shows a taser fired a charge while being pointed at the officer, use of deadly force. It's like we discussed this in the previous vlogs. You have this expectation now, a misunderstanding or a misrepresentation of the situation. You have charges, federal murder charges, that come quicker than in the McMichael's case, and you're likely, by the looks of it, in law, going to have an acquittal, which is going to set this expectation up with the public that you're going to have more outrage because of the way it's been basically packaged to the people. And yes, it's a big problem. It's a big problem. It's going to have problems now and later, if and when these 2 particular cops get off. And like you've said also, Robert, it's going to make it harder to pursue the ones that, like the Chauvin, because you're lumping these 2 situations as one and the same embodiment of the same problem when they're not, and it messes everything up.
You're going to have more backlashes by both sides, unhappy with what's been happening or what may happen later. Okay,
and now Kevin says, how do you get so much text for so little money? And my $50 super chat has 2 sentences. Did I miss the super chat? I'm trying to get the ones that are like, I'm trying to get them all actually. But Brian Wilson, second live stream in a row, you haven't mentioned my super chat. This time was a 21 LOL. No, Brian Wilson. I'm sorry, Brian. But anyways, I did it. Put your question in again if it was a question. Otherwise, Brian, thank you. Even if I don't get to the super chats, guys, I'm putting up a shirt. Sorry, you missed my super chat. Is the next merch that's coming.
I think I see just Kevin's. It feels like the public's relationship with police is beyond saving. The brave police, majority honest and hardworking, risk their everything for us. I feel like police have been so disrespected, guilty until proven innocent. There's definitely a lot of cops who feel that way right now. Now, a little counter to that, in my experience, police officers are seen as near God by most juries. So my experience has been cops getting away with a little too much deference. But it's definitely true right now. What's happening is a backlash that is way disproportionate. That I understand why the Atlanta cops were really mad about what took place. So the counter anger is reasonable.
Okay, now let's see if I'm gonna get a couple more here. I see them gonna. Okay. Oh, Sakake Onsai is gonna watch the rest later, watching Trump rally. But Councilor Barnes, your opinion on SDIY unit attorney?
Oh, that guy's nuts. One, he's a corrupt hack. I told Preet Bharara that Preet Bharara was a corrupt hack when he was there. So what's happened to SDNY is Preet Bharara's people have all been kept in power. If they want to understand who Preet Bharara kind of is, watch the show Billions. It's loosely based on him. What happened is Bharara was such a disaster because he stayed in power after Trump won. He refused to leave. These people who think they have permanent rights to power is amazing without getting elected to anything. Then, another genius Sessions decision, he decides to put Berman in temporarily to get rid of Bharara. But they don't have confidence in pushing Berman through the Senate. So there's a provision in the law that allows the court to temporarily appoint him until the president finds someone else. SDNY has been crazy the last several years. They have not pursued aspects of the Epstein case that people wanted pursued. They have not pursued aspects of the Podesta case. The Mueller team weirdly referred cases to the Southern District of New York that appear to be politically motivated. Podesta should have been referred to D.C., not New York. This is not John Podesta, but his brother Tony, involved with a lot of the FARA issues that they made such a big deal out with General Flynn. And so they haven't pursued that in New York, while at the same time they've obsessively pursued a lot of small-scale political cases involving Giuliani, involving Michael Cohen, to try to get him to say stuff against Trump on totally bogus charges when they had legitimate claims against Cohen that had nothing to do with Trump. So I've dealt with them in some other cases. They're a highly politicized branch of government that is weaponizing their prosecutorial control to either target or dismiss charges, depending on whether you're seen as pro-Trump or anti-Trump. And Berman was such a disaster that Barr finally had to push him out. And he exposed himself when he was like, I refuse to go. I hereby declare that you can't get me out. So sort of like John Bolton, these people that think they're above the law. John Bolton now may be going into prison because that idiot wanted to rush his book. And now he's not going to see any of the profits from his book. I've told people I've never been a John Bolton fan. Thought Trump made a huge mistake by hiring him. But if it turns out he goes to jail and is broke after this, I'll say maybe that was a good hiring decision by the president. But Berman is nuts. I have no respect for him. I think the Southern District of New York has been a problem ever since Preet Bharara was there. Before that, James Comey was there. I mean, so this has not been a prime place of apolitical, independent prosecutorial decisions. They did a bogus case against some other people that I've tangentially connected to. So I have problems with what's been happening up there, and it's just now blown out in the open. Now the left media's version will be that he was just about to bust Trump and Deutsche Bank, and this is why Trump is getting him fired. And that isn't why. Anybody could bring those other charges, and any kind of investigation like that will go forward. This is about a whole bunch of other problems that Berman has been creating in a wide range of where everything's political. Everybody knows now, if you're a defense attorney, Southern District of New York is picking up cases that don't even belong to them, that belong to other federal districts in the country, and they're grabbing the case because they want to make an example out of someone or have a political objective achieved in a case they have no business with. There's problems with the Dread Pirates case, the old Silk Road case. There's problems with that case that's currently under potential pardon review. So this is a rogue prosecutorial office, has been for the better part of 2 decades, and it's long overdue that bars start to clean it up. And Berman turned out to be an obstacle rather than someone who could assist with cleaning it up.
Okay, amazing. And there's a bunch of chats that we're going to get to. Steve Johnson, Laura, my girl, wants to know your opinions on the correlation between the unrest and rising race tensions and it being a presidential election year. Do these things play to the advantage of anyone? I know what I think, Robert, but I think you have a more.
The left believes it plays to them because they believe it reminds African-American voters to think through a racial filter, that if they think through a racial filter, they'll vote more Democratic come election day and may turn out more. And so they think it favors them. I do not. I think it will trigger a severe backlash. We've been through this before, 1968, and that precipitated the rise of conservative Republican control, or conservative leaning control, for a quarter of a century. So I think in the end, it will not benefit the people who are mostly behind instigating certain aspects of it in the streets and in the press.
Kelly Grant says, Viva, check your Patreon messages. I think I did, and I think I saw something about doing a specific Canadian case. Either way, I'll check my Patreon messages. Let's see what we got here. Raven Knight says there's two types of tasers. One that has a cartridge, you can shoot one person. This taser has a place to have another cartridge that can reload the taser. The other taser is one cartridge that can shoot two, but both is only two. It's interesting. I mean, undoubtedly this is going to come out in a trial.
Oh yes.
When it gets there, we'll have detailed knowledge of everything, the intricacies about it. Might there be more cops diagnosed with PTSD after all these riots, etc.? Cops and people. I mean,
Oh yes.
We went from the PTSD of coronavirus, lockdown, quarantine, isolation, to riots in the streets, the thought of losing the police, seeing what happens when you lose your police in certain areas in the States. It's no doubt there's going to be some trauma that's going to require some healing after all of this.
No doubt.
Is it reversible error to taint the jury by making it impossible for them to acquit for fear of causing a riot and violence? James Scott. We talked about this previously. You want to? I know.
Basically, it's brutally hard. It should not be. It should be easy to get a case transferred to a fair jury. There's enough people out there that could, in a country that owes over 300 million people. But the Supreme Court, when they said that the Enron case could be tried in Houston, there's no court in the country that thinks that they have to move a case anymore. So they should ask probing voir dire, jury selection questions, but I'm not confident that they will do so.
All right, and Brian Wilson, I knew I had taken, where is it here? I had taken the picture of it. I was going to get to the super chat. Any truth to the claim that the DA recently came under investigation for embezzling taxpayer money to supplement his income, among other things?
There are those rumors. It's a very aggressive political campaign he's fighting there in Atlanta, and there have been allegations of that, but I haven't seen them published in any sort of court record as yet.
Okay, and Kobe, I'm sorry, I should probably say when I'm screenshotting the chats to get to them. Sending again, don't get to catch you often. If you have time, besides don't do it, your thoughts on a midlife career change to law, especially if not needing it to provide all income?
I think the law is a great way to learn and understand the world and understand politics. And the world definitely needs more lawyers who can help people without needing an income and without needing to monetize their skill set. Absolutely. It is immensely useful, even for a young person who never intends on practicing. Oh yeah,
and an asset regardless of what you do afterwards. Plus, it also teaches you how to think critically. It teaches you how to get past the individual and only towards the argument. It teaches a bunch of good skills, but like the expression of living in New York, if you practice it for long enough, it might, destroy your soul and your optimism of life.
Indeed.
Any thoughts on the plans of the California legislature to repeal Prop 209, which is their civil rights law? Robert, I don't know. I know nothing about this. Topo Muzi.
Oh, I see what they mean. Yeah, I don't know the details about that yet. So I know there's been some discussions about that, but they're going to keep civil rights on the book in California. It's only about whether they strengthen them and expand them in new and interesting ways, because that's the way California is. Sometimes good ways, sometimes not so good.
Okay, and so we'll close off the Chaz, because I don't think we're gonna get much.
There's not a lot. That's about it for right now. It's a crazy time to be alive. That's what it is.
Can you imagine? I mean, so it was called Chaz. What was it called? I forget what Chaz.
The Capitol Hill Autonomous Zone.
Yeah, and then they changed it to CHOP, which they thought would be an acronym that better suits the movement.
It does, that, and that's what they're saying. What happens to people who become problems? Their heads get chopped. It's like, and they're actually chanting that. They're chanting from the Robespierre thing.
How long do you think before the military gets involved and goes in? I mean, or National Guard or some form of intervention meaningful to secure it?
I think they want to force Trump's hand, and I think Trump wants to force their hand. So I think we're going to be a little bit of détente for a couple more weeks. Okay. It'll only be when big corporations in Seattle tell the mayor to clean it up, tell the governor to clean it up. It's like in Vegas. I told everybody, as soon as the casinos tell the governor time to open up, that governor's going to suddenly reverse all of his opinions about COVID. And by golly, he did. The governor, all of a sudden, when the casinos wanted to be open, he was like, no, everybody can go wherever. No problem. It's the Microsofts of the world that run Washington if they want to. So that's what will happen.
And it's disconcerting. Like I was thinking about it here, is people are playing politics with real people's lives. And it's not the individual, the lowly hoi polloi's interests that are governing anything. It is depressing to watch and really fully appreciate, and tough not to get cynical, but we always have Billy Madison or Happy Gilmore to watch for a good laugh. Mr. Cooper, if Mr. Barnes, are you familiar with FBI railroading case of Schaefer Cox, and does Mr. Barnes think there are any chance that the ridiculously unjust, if not corrupt, civil asset forfeiture laws will soon or ever be corrected?
I think that have to be my last answer. I have to hop on this other interview here in a minute. I don't know about Schaefer Cox. I do believe that the forfeiture laws are insane, and that I do think there will be some changes to them within the next 10 years.
Okay, Robert, this will be the first time we don't talk after the stream. I'll stick around here and read some of the remaining super chats and end up the stream. Thank you very much, as always.
Absolutely.
We will do this sooner than later. We'll DM.
Adios and adieu.
Okay. All right, everybody. First of all, I'm going to always apologize for missing super chats. It makes me feel guilty, but I see them, everybody sees them, and I think everybody appreciates the support of the channel. So let me, now that I no longer have to worry about interrupting Robert, let's get to these and see what I can feel. Almost like I feel weak without Robert. Like, if I don't know an answer, now there's going to be a silence that no one's going to answer it for me. Now, Dave, once you're a government employee, isn't there a 2 year restriction for anything related to government work? Shouldn't that apply to public books also? So, another thing, I mean, I don't know this, but I just know that they sign NDAs, especially when they get into these types of environments. And the idea that they can publish a book during the current administration for which they were serving, it doesn't make sense to me, but I don't know how this works in the States. And, culturally, in the sense of Canada versus the U.S., we don't have this type of problem. And out here, as we've seen with the Rebel News, people get in trouble with the federal government for not even being insiders writing books about the government during time of elections. So it is crazy. Hey, Dr. G says 30-year retired college professor, force expert for both sides. Please contact me if you need answers so much information. I will screenshot you, Dr. G. David at vivapride.com. You can email me. I tend to get some more emails because it's easier to do. What happened here? I see a lot of F's now. What happened? Oh, we lost line. So thank you very much for that. I think I did miss a couple more super chats. Nicholas Rome says, do you think the left is following the footsteps of the SDS, whether underground organized society in 1967 history? I'll screenshot it and see if Robert can get to it next time. And then we got Ozian says, I agree with law school non-lawyer here, and no intent to practice, but the best thing I ever did my 40th just in chief night school, LOL. Is my audio gone? Oh no. How about now? How long have I been talking and nobody's been able to hear me? Hold on a second. One second. Sorry, guys. One second. What are the chances you're hearing the audio now? Yay or nay? Well, that sucks. Well, the mic, let's see if it's working now, people. I think the mic says it's working. This is a first. At the very least, it happened an hour and 45 minutes in. Oh, God. Well, sorry, guys. Son of a bee sting. Okay, it's fixed. I say, okay, small blessings. It happened at the end and not in the middle or at the beginning. I read some of the super chats. What was I talking about? I was just thanking everybody. Oh, that's what I was saying. Okay, first of all, thanks for hanging in there and sorry for the glitch. I was thanking everyone for the super chats that even if I miss them, I see them, everybody sees them, and I think everybody appreciates supporting this channel and this endeavor with Barnes, which I think, like, I know what Barnes is going to do. He's going to take everything that we get from this and put it into, I imagine he's going to put it into Free America Law Center. It might be a great way to do it. But thank you all for supporting this. By the way, I wasn't binding Barnes to anything. I shouldn't have said that. Now I'm going to obsess over that. So thanks for the super chat. Sorry for missing a bunch, and now I can't even see the ones that I missed. So that's it. I think that was good. It's amazing. When I first learned in this venture of the vlog that the police have no duty to protect. I just want to make sure I'm getting my words right. I was blown away, and people have a difficult time understanding that. So it's amazing. Let's see here. Video, Viva, you're breaking up right now. There's a problem with your audio. Okay, we're gonna end it. Sorry, guys. Thank you. I'll see you the next time, sooner than later. See you in the vlogs. Happy Father's Day to all the fathers, sons, brothers out there. Someone baited me. Okay, son of a gun. Either way, tomorrow is Father's Day. I should probably go out there and have dinner. I think 7:50. It's time for dinner. So now Kelly's in trouble. So all that to say, it was a good one. Sorry about the technical difficulties. Sorry for missing super chats. We have a new member, Jack. Where is it? Where's Jack's new member? We want to see Jack. Jack, welcome to the channel. Welcome to the membership. You get sneak peeks of the videos. So do Patreons and subscribe stars. And that's it. Let's see. There was one more here. Viva, you're breaking up right now. Problem with your audio. Okay. Let's see this here. Viva, might I suggest keeping the chat open in 2 windows or monitors so that one is in real time and the other you can walk through slowly for super chats? Incidentally, actually, if anybody has a good solution for this, because it is a problem that I'm running into now consistently, there's got to be a solution where I could see all the super chats and they can stay, up. I'll figure out. If anybody's got solutions, email me, david@vivafry.com. Still doing my best, and I hope it's good enough. Happy Father's Day. Thank you, and happy Father's Day to all the fathers out there. It's the longest day of the year tomorrow. I'm not sure which way to read that in terms of a metaphor. Okay, let's do it. I'm gonna go upstairs and have dinner. Thank you all for tuning in. I'll see you tomorrow. Have a good weekend and stay healthy. Check in on your friends, neighbors. Make sure everyone around you is doing good. Ending broadcast. Peace out, people.